So today we are facing a repeated power failures here. My laptop has certain problem. Okay, it's back. Sorry, no problem. So anyway, uh, so we know that when it comes to penal statutes, there is strict construction. Now the thing is, strict construction means that we are to go by the literal meaning of words. Okay, but due to developments in science and technology, sometimes the words, if we go by the traditional meaning, it will then lead to creation of certain problems. Okay, so quite often the judges have to go by the dynamic meanings, okay, contemporary expositio, as I referred to earlier, okay, of the words. I have not explained it, so we are to go by the contemporaneous meaning of particular word. So that is something that we have to keep in mind, okay, and it does not frustrate, it does not negate the strict construction of penal statutes rule. So in R versus Ireland, 1997, just a second. So in this particular case, psychiatric injury caused by silent phone calls was held to amount to assault and bodily harm. So you know how assault and bodily harms, like in normal situations, understood. Okay. However, in this particular case, because of this changing technological development, psychiatric injury caused by silent phone calls was held to amount to assault and bodily harm under section 20 and 47 of a particular act of 1861. Similarly, in R versus Fellows, 1997, in this particular case, data stored in computer disk was held to amount to indecent photograph within the meaning of Section 1 of Protection of Children Act, 1987. Now, as you know, indecent photograph is traditionally understood as something else, real photograph, the physical photograph. Now, in this particular case, even what is stored in the computer disk, CD, I'm guessing, would also have also been considered to be within the meaning of indecent photograph under the said provision of the act. So that's definitely there. So Justice Story, okay, Judge Story, as you famously know, in US versus Wynne, just a second. In this particular case, said that penal statutes are not to be enlarged by implications or extended to cases not obviously within their words and purport, but where the words are general and include various classes of persons, I know of no authority which would justify the court in restricting them to one class or in giving the narrowest interpretation, where the mischief to be redressed by the statute is equally applicable to all of them. So see, as I discussed earlier, the mischief rule, okay, that has to be kept in mind, and in such case, narrower interpretation by the judges are not to be forgotten. Similarly, public policy, okay, also plays a part in how a penal statute is interpreted. So in such case, you see, this kind of goes against the idea of preference of liberty. But when the public policy requires, that's the kind of interpretation which is to be preferred. So in the case by the name R versus Brown, just a second, I will get there. Okay, so in R versus Brown, so in this particular case, it was held by the House of Lords that consensual sadomasochistic homosexual encounters which occasioned actual bodily harm to the victim were assaults occasioning actual bodily harm, and contrary to Section 47 of Offences Against Persons Act 1867, and unlawful wounding contrary to Section 20 of that Act, notwithstanding the victim's consent to the acts inflicted on him. The court basically took into consideration public policy required. Now anyway, this seems to be a problematic decision in today's time. In today's time, what would be considered as assault or actual bodily injury, I think bodily harm, I think the meaning will change. I don't know, public policy as it was understood back then, this was the I think it depends on the degree to which the bodily harm happens. Okay, so if it involves some real bodily harm, then maybe that's what they were referring to. So obviously that will be considered, as I understand from having read this much of the facts. Yeah. So anyway, another important case that we can look at is by the name W.H. King and Republic of India, 1952. So in this particular case, Section 19 of Bombay Rents, Hotels and Lodging Houses Rates Control Act is our concern. Okay, in this particular case, the said act, prohibited a tenant, okay, to claim or receive any sum or consideration as a condition for relinquishment of his tenancy of any premises. So the question that is pertinent for us is, what does relinquishment mean? Okay, so it says it prohibits the tenant to claim or receive any sum or consideration as a condition for relinquishment of his tenancy of any premises. Now, what does relinquishment mean here? Does it apply only with respect to the lesser, or is it any other form of relinquishment? So it was in this particular case, the Supreme Court applied strict construction and held that the court is in this particular case, the court basically went ahead with the narrower meaning, okay, that relinquishment only as against the lesser, okay, and not as against any others, okay, and not as against any others. So sublease is allowed, okay, because then the relation is not between the the landlord and the tenant, but some other lessee, and the tenant now being the lesser. Okay, so some sublessee and lesser. So that is fine. Okay, but so the word relinquishment applies only as against the landlord here. That is the original lesser. So the Supreme Court construed the provision strictly and held that the court is not concerned so much with what might possibly have been intended as with what has been actually said in and by the language employed in the statute. So that's what has been held in this particular case. So yeah, so it was held that an assignment of tenancy by the tenant, okay, so an assignment of the tenancy by the tenant for consideration in favor of a third person did not come within the prohibition, and that the relinquishment contemplated under the section was equivalent to surrender of tenancy in favor of the lesser. So that's the only interpretation that it went ahead with. So the next, I think one or two, three cases will probably make it clear. The next important case is by the name Sarju Prasad versus State of UP, 1961. So in this particular case, we are concerned with Prevention of Food Adulteration, Act 1954. So in this particular case, Section 16 deals with penalties, okay, and Section 19, the defenses which may or may not be allowed in prosecutions under this act. And as you know, whenever food adulteration comes, matters relating to food adulterations, etc. come, then there is no scope for leniency, etc. They are to go ahead with strict interpretation in such situation. So the defenses where it shall be no defense in a prosecution for an offense pertaining to the sale of any adulterated or misbranded article of food to allege merely that the vendor was ignorant of the nature, substance or quality of the food sold by him, or that the purchaser having purchased any article for analysis was not prejudiced by the sale. So that's basically the idea, that in such cases nothing else will be looked at. Okay, the very defenses says that, well, ignorance is not an excuse. So in such case, okay, in these matters, very strict interpretation is to be applied. In one more case by the name Sakhuja versus Allen, 1972. In this particular case, we are concerned about Section 2(1) of Road Traffic Act 1967. Okay, and it says, a constable in uniform may require any person driving or attempting to drive a motor vehicle on a road or other public place to provide a specimen of breath test there or nearby if the constable has reasonable cause to suspect him of having alcohol in his body, or to suspect him of having committed a traffic offense while the vehicle was in motion. Okay. Now the question is the test based on this application of this particular provision, can the test be conducted only when the person is driving, or can it be, basically, can the test be conducted even after someone has completed driving? Okay, so it was held that, I mean, obviously it will depend on this in the circumstances. Not every situation will the officer have that particular power, but it need not be only during a person is driving. That's the interpretation it came to. So, considering this section, it has been held that the driving or attempted driving did not have to be exactly contemporaneous with the requirement to provide a specimen of breath. And a person could be required to provide a specimen even though at the moment when the requirement was made, he had ceased driving or attempting to drive, provided that the sequence of events between the observed driving or attempted driving and the requirement to provide the specimen followed on each other so closely as to form continuous sequence. So yeah, as I said, not in every case, but in certain cases, from the facts, it can be clearly established that, well, immediately driving or attempted driving has happened. So it need not be only while the attempt is being made or driving is being done. Okay. But even if it is afterwards, but you can establish a sequence of events, then definitely it comes within the purview of this particular provision. So that's the that's the conclusion that it had arrived at in this particular case by applying this particular rule. So we'll take one last case and that would suffice. Okay, this case goes by the name Municipal Corporation of Delhi versus Lakshmi Narayan Tandon, 1976. So, in this particular case, we are concerned with the definition of sale, okay, in Prevention of Food Adulteration Act. As I said, when it comes to laws relating to adulteration, the application of the law is very strict, as the law itself quite often makes it crystal clear, okay. So in this particular case, we are concerned about the definition of sale in the said act, okay. And it has been, held similarly in other cases as well, okay. So it has been held in this particular case that sale in the act would include all commercial transactions whereunder an adulterated article of food is supplied for consumption by one person to another. Therefore, supply or offer of food by a hotelier to a customer when a consolidated charge is made, so basically separate sale is not made, okay, for residents and other amenities including food falls within the definition of the sale. So even when a hotelier, who originally, generally only makes accommodation available, but they were also supplying food articles, okay, whether that would come within the meaning of sale, it was held that well, we'll go with that broader definition, and thus that will come within the purview of the application of the word sale under Prevention of Food Adulteration Act. And that's how strict interpretation when it comes to penal statutes is done. So in the next class, we will